The Dakota Proclamation by Meredith Quinn, Musa. Page 88. Indian Sovereignty versus United States Citizenship. June 2nd, 1924, 68th Congress, Session 1, Chapter 233, an act to authorize the Secretary of the Interior to issue certificates of citizenship to Indians. Nobody has to tell the truth. Is the Indian a citizen of the United States? When this question is asked of Indians, doctors, bakers, lawyers, or bums, they all stand and shout, "Yes, the Indian is a citizen of this country. In fact, he is first citizen, the first American. If he isn't a citizen, who is? Call your local Bureau of Indian Affairs, and he too will tell you that the Indian is a citizen of this country." Former Indian Commissioner Brophy, who wrote The Indian, America's Unfinished Business, Edgar S. Kahn, author of the book Our Brother's Keeper, and Monroe Price, who headed the law department at the University of California, Los Angeles, all state that the Indian is a citizen of the United States. When such learned men say such a statement, it is a fact. Because of their academic status, this statement is not to be questioned. I, as an Indian, born on the reservation in Sisseton, South Dakota, question this statement of fact. If this is the best that the Indian or legal council or educational institutions can come up with as correct and legal information, then the American Indian must look to other sources for guidance to becoming civilized. This Indian is by no means legal counsel or an attorney, but I challenge the American bar and their members to disprove my legal identity of the American Indian, or the Indian of this hemisphere. In fact, one of the biggest problems of the Indian is that too many learned men make statements that have no truth. It is either intentional or they are plain stupid. Either way, the Indian suffers. Okay, let me ask the question another way. Is the Indian a member of a sovereign nation or citizen of the United States? Now it becomes a subject for controversy. But the controversy was created by ignorance, not only of the Indians, but of the anthropologists, archaeologists, historians, and members of the legal system of the United States. The Indians' ignorance has good cause. First, blame the educational institutions, who are established information centers qualified as carrying records of truth. Next, blame trickery. Lastly, his lineage families and leaders were murdered without reason, leaving him in a limbo state. But who constructed this confusion that he was a potential citizen and that he had rights together into facts? There is no question that this was planned. The rules and facts are very clear, and the United States, who follow its laws to the letter, wrote statutes in such a manner that if they were caught, they could always come up with one or two answers to any questions asked. From what is still on the books, the following answers can still be used. 1. As your guardians, We were waiting for you to learn how to run your independent nations, or two, as your guardians, because you always remained in the savage state. We could not permit you to run loose. We had to make slaves out of you. The impossible becomes a lie. To make sure that no one is left confused, let's follow all the steps that would make a full legal citizen of the Indian. We must first overcome two problems. One, the issuing of a certificate. Two, getting past the wording provided, which is always in any legal act that deals with the Indian. Let's approach the concept that the American Indian is a legal citizen of the United States, which seems to be the most popular today, even though it's untrue. The guidelines for this are about the same as for a member of any other sovereign nation who is coming to this country to get citizenship of the country. I'm talking about procedures only. Now, because the American Indian has a guardian brought about by a land-based sovereignty right, which the United States is not too sure it can hold in trust and must protect themselves, because of all the countries that have exchanged their right to this territory, i.e. England, France, Spain, and Russia, the U.S. has never defeated the Indian tribes of America. And these Indians still hold claim to this territory. So the first job the Indian must accomplish is to remove guardianship. This task would stop a Philadelphia lawyer. The Indian starts by proving to the Secretary of the Interior that he is the head of household and over 21 years of age. Ever know an Indian that could get in to see the Secretary? Oh, if he does this, next he must prove he has abandoned all tribal relations. There isn't even a statute for the Indian to do this. If he can do this, he has a waiting period of around 5 years, after which he will receive a, quote, certificate of tribal abandonment, end quote. The next step is to get the Secretary of the Interior to give him a competency test. If he passes, he is brought before a duly authorized competency commission. Never heard of them. The Indian is now entitled to a, quote, certificate of competency, end quote. I don't even know where to look for this, but it entitles the Indian to 160 acres of vacant land, which must have laid vacant 5 years. Should this land appear for this Indian, he can claim homestead, but the Secretary of the Interior holds the title of this land for 25 years, after which he helps this Indian write a personal bill relieving guardianship, alienation, and severalty. He presents it to the Congress that must pass it with a vote. If it does, the Secretary of the Interior gives him his land title and a certificate of citizenship. It now has taken about 40 years of this Indian's life, having to start when he was 21 years of age, to become a legal citizen of the United States. And this is for the so-called first American. Just how long would it take other groups to become legal citizens? Or does black man, Mexican American, Spanish surname, Mongolian, or other non-European think they're United States citizens? Then welcome to the stupid club. I forgot to mention that if an Indian leaves their reservation, it does not make him a legal citizen. The question whether the members of any Indian tribes may be admitted to the privileges and responsibilities of citizenship is a question that must be decided by the government and not each Indian himself, Elk versus Wilkins, 112 U.S. 94, 28 LED, 643, 5 SCR 41, U.S. versus Osborne, D.C., Oregon, 2 Fed 58. Congress has authority to empower a commission to determine who are entitled to citizenship in each of certain Indian tribes. Stevens versus Cherokee Nation, 174 U.S. 445, 43 LED, 1041, 19 SCR 722. When the United States grants privileges of citizenship to an Indian, gives him the benefit of, and requires him to be subject to the laws of the state, it places him outside the police regulations of Congress. In the matter of Hef, 197 U.S. 488, 49 LED 848, 25 SCR 506. A treaty providing that those Indians who did not wish to move to a reservation west of Mississippi River and were desirous of becoming citizens of the state in which they resided and were qualified to take care of themselves could remain and receive certain benefits and lands, does not confer citizenship on the Indians. U.S. versus Boyd, CCA 4, 83 Fed 547. The 5 Citizenship Acts for the Indians. Let's take a look at these Citizenship Acts. First Citizenship Act. It was called the General Allotment Act of 1887, the Dawes Act. The Indian was to be allotted 160 acres of vacant land to be held in trust for 25 years, after which the president was to issue land title and a certificate of citizenship. In 1906, the president signed into law an act prolonging this law indefinitely. But it gave the Secretary of the Interior the right, if he found a competent Indian, to grant land and citizenship rights. This act was enforced 68 years till it was repealed by House Concurrent Resolution 108-1952. The Solicitor of the Interior called it a dead letter. 66th Congress, Session 1, Chapter 95, an act granting citizenship to certain Indians. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that every American Indian who served in the military or naval establishments of the United States during the war against the Imperial German government, and who has received, or who shall hereafter receive, an honorable discharge, if not now a citizen, and if he so desires, shall on proof of such discharge and after proper identification before a court of competent jurisdiction, and without other examination, except as prescribed by said court, be granted full citizenship with all the privileges pertaining thereto, without in any manner impairing or otherwise affecting the property rights, individual or tribal, of any such Indian or his interest in tribal or other Indian property, received by the President, October 25th, 1919. Note by the Department of State. The foregoing act having been presented to the President of the United States for his approval, and not having been returned by him to the House of Congress, in which it originated within the time prescribed by the Constitution of the United States, has become a law without his approval. This Citizenship Act was repealed after 33 years of an Indian believing he was a citizen of the United States, and it was repealed in 1954 because no Indian applied for it under the Reorganization Act. Third Citizenship Act, 68th Congress, Session 1, Chapters 231 to 234, 1924. Chapter 233, an act to authorize the Secretary of the Interior to issue certificates of citizenship to Indians. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that all non-citizen Indians born within the territorial limits of the United States be, and they are hereby declared to be citizens of the United States, provided that the granting of such citizenship shall not in any manner impair or otherwise affect the right of any Indian to tribal or other property. Approved June 2nd, 1924. The Citizenship Act of 1924 is the most quoted by government agencies, attorneys, and educators. This quote by them greatly harms the Indian because court history is made from this misquote. Please note the first line where it states that a certificate of citizenship is to be issued. 76th Congress, 3rd Session, an Act, Chapter 876, to revise and codify the nationality laws of the United States into a comprehensive nationality code. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that the nationality laws of the United States are revised and codified as follows. Title 1, Section 1. This act may be cited as the Nationality Act of 1940. Chapter 1, Definitions. Section 101. For the purposes of this act, A, the term national means a person owing permanent allegiance to a state. B, the term national of the United States means 1, a citizen of the United States, or 2, a person who, though not a citizen of the United States, owes a permanent allegiance to the United States. It does not include an alien. Chapter 2, Nationality at Birth. Section 201. The following shall be nationals and citizens of the United States at birth. A person born in the United States and subject to the jurisdiction thereof. B, a person born in the United States to a member of an Indian, Eskimo, Aleutian, or other Aboriginal tribe, provided that the granting of citizenship under this subsection shall not in any manner impair or otherwise affect the right of such person to tribal or other property. The Citizenship Act of 1940 was revised and replaced by the 5th Citizenship Act, December 24th, 1952. Subchapter 3, Title 8, Aliens and Nationality. Subchapter 3, Nationality and Naturalization. Part 1, Nationality at Birth and Collective Naturalization. Section 1401, Nationals and Citizens of the United States at Birth. A, the following shall be nationals and citizens of the United States at birth. 1, a person born in the United States and subject to the jurisdiction thereof. 2, a person born in the United States to a member of an Indian, Eskimo, Aleutian, or other Aboriginal tribe, providing that the granting of citizenship under this subsection shall not in any manner impair or otherwise affect the right of such person to tribal or other property. 3. A person born outside of the United States and its outlying possessions of parents, both of whom are citizens of the United States, and one of whom has had a residence in the United States or one of its outlying possessions prior to the birth of such person. This Citizenship Act is still in force. If becoming a citizen for the Indian is so cut and dry, let's put all the citizenships acts on a graph. Citizenship Act enforced by number of years. 1887, enforced for 65 years. 1919, enforced for 33 years. 1924, enforced for 46 years. 1940, enforced for 12 years. 1952, at the time of the writing of this book, was 18 years. Total all the years of Citizenship Acts for the Indian, and you have 164 years, which is only 17 years short of when George Washington took office in 1789. The Citizenship Acts for the Indians, when court tested, showed that if the Indian would have taken some of these acts through their procedures, it still would not have made their children citizens. Whenever an Indian is in a problem that originates from his land-based reservation, no judge will dare give the liberty of citizenship to the Indian because it would free the control of the land base. The Indian is called a citizen as long as property, real, unreal, or interest therein is not brought into the questions of jurisdiction, because property is controlled by Congress. The word property automatically imposes guardianship, alienation, and severalty, which forces Congress to produce an act relieving this control before citizenship could be issued. If you still want to argue that as Indians we are citizens of the United States, experience proves otherwise. Of the 102 tribes and villages terminated under House Concurrent Resolution 108 from 1953 through 1960, this court decision handed down made it clear of these 102 tribes terminated, quote, they had no recourse to constitutional rights, end quote. If you don't believe me, ask the Klamath Falls Indians, who now have no reservation or treaty to protect them. Certainly the United States won't. Now comes the nitty-gritty conclusions to all that has been written about citizenship. Why don't it work? The courts are being tested by Indians trying to prove he is not a citizen, and the judges are ruling that he is. Why? First, experience shows that the Indian is never able to get the question of jurisdiction of his sovereignty into the court procedures of the legal system of the government, because there is none. This is an exclusive right of the Congress and the Secretary of the Interior. See 43 USCA 1461, 1464.